Hello everyone. In this video, we will discuss an overview of various anti-bullying laws in India. But before that, first let us understand what is bullying. Bullying is a repeated aggressive behavior aimed at causing harm, distress, or intimidation to another person who typically has difficulty defending themselves. It can manifest in various forms such as physical, verbal, social, or online. And we'll look at some of the illustrations of bullying to understand what it can look like. The first example is of verbal abuse. Verbal abuse can be when a group of students continually taunts and ridicules a classmate, making hurtful comments about their appearance or personality. So if a group of students taunt a particular student and make him feel bad, it is an example of verbal abuse. Then our second example is physical intimidation. It means you are actually making someone fearful physically because of a larger stature, maybe, or maybe a dominant position. You are physically scaring away a person. The example can be a larger student consistently pushes and shoves a smaller student, taking their belongings or blocking their way in the hallway. This is a classic example of bullying in the form of physical intimidation. It can also be if a small petite child is sitting at the bank of a swimming pool and a big child comes and pushes him into the pool intentionally just to make him afraid of him. That is also an example of bullying. Bullying can also be in the form of cyberbullying, which means the bullying is taking place online. It is not taking place in a physical place, but somebody is passing online derogatory comment or sending you messages that scares you, causing harassment. That is cyberbullying. Example can be co-workers engaging in online harassment, spreading rumors or derogatory remarks about a colleague through email, social media, or online forums. And the fourth is exclusion and isolation. Imagine you are in a workplace where a group of colleagues intentionally exclude and ostracize you from team activities or social gatherings. Always, how would you feel? That would definitely take a toll on your mental health, and that is an example of bullying. Since we discussed that how would we feel if we are ostracized or bullied at a place, and we clearly realize that it would not feel nice, right? So we would also take a moment to analyze about the other harmful effects of bullying to understand why do we need anti-bullying laws in the first place. The harmful effects of bullying can include anxiety, depression, stress, loneliness, self-withdrawal, nauseatic tendencies, insomniac tendencies within the bullied person. The bullied person may be scared of life and may go through all these problems which can be seen in the slide. So bullying is not a small problem. It is rather a menace and it can have all these harmful effects. So it becomes necessary that we have some anti-bullying laws in any country. So we would now try to analyze the various forms of bullying one by one to understand how each of them can be tackled as well. Firstly, the first type of bullying that we can discuss about is workplace bullying. Workplace bullying is where you are bullied in your professional atmosphere or your professional setting where you have to go for your job, but you may face social exclusion, your work may be undermined, or somebody may take away somebody else's credits without any mention or acknowledgement of their hard work. All this behavior can impact a individual's mental health, confidence, and productivity and can be counted as bullying. Another example of bullying at workplace can be pushing someone to grant some unwarranted favors because of hierarchical superiority in the workplace ladder. Sexual harassment at workplace is the most common manifestation of this kind of bullying. If the boss or the superior is pushing its subordinates to grant some sexual favors, then that can be counted as sexual bullying. And harassment at workplace and the Supreme Court provided basic definitions of this sexual harassment and workplace and gave guidelines to tackle it in the case of Vishakha and others versus the state of Rajasthan and others 1997, commonly known as the Vishakha guidelines. A legislation finally came into place in 2013 and under the name of the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. The landmark ruling by the Supreme Court underscored the pivotal role of international conventions and norms in interpreting the constitutional guarantees of gender equality, the right to work with human dignity, and the inherent safeguards against sexual harassment in the Indian Constitution. This influential interpretation of the Supreme Court played a crucial role in catalyzing the enactment of the formal legislation in 2013, specifically addressing and combating sexual harassment at workplace. However, there isn't a singular comprehensive law solely dedicated to preventing all forms of workplace bullying. Instead, there are various provisions dispersed across different acts aimed to address the various forms of bullying at workplace. Because this act, Sexual Harassment of Women at Workplace, is particularly to prevent sexual harassment of women at workplace. What about men? What about other forms of harassment at workplace? So, to deal with that, we have scattered provisions, but we do not have a comprehensive legislations. But I will discuss the scattered provisions one by one so that we know about them at least. Firstly, the first provision is about the timely payment of wages. Section 5 of the Payment of the Wages Act ensures that employees receive their wages promptly. This is to ensure that bosses or superiors do not make any undue delay in the payment of wages for which you have given due service. If we deserve the payment, we have to be granted that timely, and that is ensured by Section 5 of the Payment of Wages Act 1936. Also, there are limits on deductions. Section 7 to 13 of the same act outlines specific guidelines regarding deduction from wages, ensuring that superiors or the wage payer cannot make unreasonable deductions in your wage, and the deductions are reasonable and lawful and not excessive. The third provision is equal pay for equal work. This is also aimed at bringing gender parity, because if a man and a woman are delivering the same amount of work and are doing the same nature of work, the Equal Remuneration Act of 1976 mandates that employees should be paid equally for equal amount of work. The fourth provision we would discuss is non-discrimination of persons with disabilities. Now, this is a very important thing because we often tend to look with people with disability with a lot of insensitivity, hatred, and a sense of superiority over them. But it is important that the person with disability also do not face any kind of bullying at workplace, so that their mental health is not affected. For this reason, the Section 24 of the Persons with Disabilities Act 1995 emphasizes non-discrimination in employment practices and promoting fair opportunities and accessibility for individuals with disabilities in the workforce. And there are other legislations as well aimed for promoting gender parity at the workplace, that is non eliminating sex based wage discrimination as per Article 39D of the Constitution and Section 2H of the Equal Remuneration Act 1976, which obligate employers to ensure equal remuneration for both male and female employees performing similar work. This is very similar to the equal pay for equal work provision. Then we can discuss the Industrial Disputes Act of 1947, which oversees that employment agreements are regulated, and Chapter 5A governs that procedures related to layoffs and retrenchment are followed by the companies in a manner that it does not harm the employees and does not lead to any sort of unfair treatment. And the last provision we shall discuss in the context of workplace bullying is maternity benefit protection, because for a safe workplace where you work with dignity, it is also needed that there are some holidays and leaves that are granted to you. That is the primary difference between an organized workplace, organized sector, and the unorganized sector. So in the organized sector, the Maternity Benefit Act of 1961 safeguards the rights of women during pregnancy by ensuring non-discriminatory treatment in the workplace, that women are not lagging behind in their career because of the natural biological experience of maternity. So the benefit of the protection ensures that they are also having a fair place in the workplace. So these provisions collectively serve as crucial safeguards to address numerous forms of workplace bullying. They help to prevent various unjustified deductions from wages, delay in wage payment, disparity in pay for equal work, discrimination based on disability, etc., etc., whatever we discussed above. Now, apart from all these, we can also tackle workplace bullying with the help of direct communication with the bullies and expressing firmly that they need to stop their behavior. We can also engage the management. If the direct communication does not work, the employee can approach the HR manager or the required cell to make them aware of the situation and seek their support in resolving the matter, because it is ultimately the employer who is responsible for providing you a safe and dignified workplace. You should be aware about the legal rights as well, which we discussed above. And then it is also important that if the bullies also target your co-workers and colleagues who might also be the victims of the same kind of bullying, together you can compile a report detailing the incident and present it to the appropriate authorities within the company fearlessly. You can raise your concerns in meetings if the opportunity comes, or as the last resort, if you have no other option, you can consider leaving the job if the bullying persists despite efforts to address it. First, take efforts to address it. However, ensure you have alternative job opportunities lined up before resigning. Having a backup plan is essential for a smooth transition. Ultimately, addressing workplace bullying involves a combination of assertive communication, seeking support from management, understanding legal options, documenting incidents, solidarity with co-workers, and having a backup plan in case leaving the job becomes absolutely necessary for your individual well-being. Now we would discuss the second kind of bullying, that is bullying in schools and other educational institutions. Bullying in schools is an exceedingly sensitive matter because of the involvement of minors, both as bullies and as the bullied victims. Bullied victims may develop behavioral disorders and long-term social anxieties due to the traumatic incidents they experienced during childhood, and the bullying child may also be oblivious of the severe consequences they may face because of their action. Both the bully and the bullied are minor in this case, which makes it a sensitive issue in case of bullying in school. However, in case of colleges, the matter is dealt by adults, and still bullying remains a sensitive issue because ultimately in a place of education, if somebody is facing mental anxiety and mental torture, trauma in the pursuit of education, that is not a good thing to begin with. So it remains a sensitive issue irrespective of whether it is happening in school or in other educational institutions like colleges and other places. Unfortunately, there are no specific legal measures in India to address bullying within schools. Essentially, bullying itself is not considered illegal in any statute. However, if a person engaged in bullying behavior cause instigates a person to do self harm, and the bullied child tragically takes their own life, the perpetrator can be held accountable for abetting suicide under section 306 of the earlier Indian Penal Code. Could be the perpetrator could be held accountable. This provision may have changed in the new IPC, but there was this provision. This means that legal action is only taken after the consequences of bullying have resulted in severe outcomes. This significant flaw in the legal system allows bullying to persist as a recurring issue within schools. The earlier IPC encompassed various sections that, although not explicitly targeted bullying, but had aspects of behavior associated with, such as sections such as 339 dealt with wrongful restraint, section 340 dealt with wrongful confinement, section 506 addressed punishment for criminal intimidation, section 323 related to the punishment for causing hurt voluntarily, and the aforementioned section 306 dealt with abatement of suicide. All these sections are related to bullying behavior. However, a specific and comprehensive legal framework solely dedicated to addressing bullying in its various forms is currently absent within the Indian legal system. The CBSE, however, has implemented some measures to address bullying within schools. The Ministry of Resources Development directed CBSE schools to establish anti-ragging committees at school level. However, it is important to recognize that all the schools in India are not under the CBSE board. So the other boards have no specific provision for anti-ragging committees. Additionally, the schools were instructed by the Ministry of Human Resources Development to take firm actions against students engaged in bullying behavior, with rustication being the most severe penalty in special cases. But unfortunately, these directions were only for the CBSE schools, and we know that there are other schools as well. The ministry urged schools to utilize notice boards to caution students about the repercussions of bullying. A report from the Raghavan committee recommended holding school teachers and principals accountable for incidents of bullying that occur on school premises. It emphasized the need for the school system to adopt measures similar to the UGC's strict approach towards curbing ragging on college campuses. Now, apart from the schools, we also have colleges as significant educational institutions. In colleges also, UGC has strict guidelines that there has to be anti-ragging committees, cells and posters making people aware of the consequences of bullying. And most importantly, the university's recognition from the UGC can be forfeited if bullying continues and there are reports of bullying from the students of this university. So that is a forward-looking approach taken by UGC to curb bullying in the college campuses. And the report from Raghavan committee was also instrumental in ensuring that the CBSE schools also implement anti-ragging committees at some places. Article 21 of the Indian Constitution guarantees the right to life and personal liberty, emphasizing the dignity of individuals. Educational institutions, therefore, bear a responsibility to safeguard human dignity and ensure that no individual is subjected to lasting trauma in the pursuit of education, which is invariably a fundamental and invaluable aspect of life. Last but not least, we have cyberbullying. Cyberbullying is a recently emerging significant issue. This is the bullying that takes place online. People sending, we discussed what cyberbullying is. So, this is a menace because the online realm offers anonymity to the bully, providing educated individuals, including the youth, with a secondary life that often goes unchecked. Even a educated person can troll somebody in the comment section of somebody's post because that person may be registered with a fake name or account in the social media platforms. The bullied person may have a toll on the mental health because of the comment, but the bully may not be identified because he or she may have an anonymous account with a false fake name, and the IP address would not be tracked unless an extreme criminal activity takes place. So ultimately, this anonymity becomes the tool in the hands of the criminals or the bullies in the incidences of cyberbullying. Cyberbullying involves the use of digital and electronic devices to continue with your bully behavior. It can include platforms like social media, as we discussed. Cyberbullying takes different forms, such as posting humiliating content, hacking victim accounts, sharing vulgar messages without consent, issuing threats for coercive actions, and involving child pornography or threats thereof. The detached and the impersonal nature of social media platforms often makes it very easy for individuals to behave in a more mean spirited, animal like manner. India lacks specific legislation again solely dedicated to cyberbullying. However, certain legal provisions address aspects of it. For instance, Section 67 of the Information Technology Act pertains to publishing or transmitting obscene material online and can lead to imprisonment for up to 5 years and fines up to 10 lakh rupees. Additionally, Section 507 of the earlier Indian Penal Code dealt with criminal intimidation through anonymous communication punishable by imprisonment for up to 2 years. Meanwhile, Section 66E of the IT Act also addresses privacy violations involving the transmission, capture, or publication of private images, penalizing offenders with imprisonment of up to 3 years or a fine of up to 3 lakhs. These laws encompass various elements related to anti bullying and cyberbullying within their scope in India. Additionally, offenders of cyberbullying among university students can face criminal liability under the Code of Criminal Procedure 1973. Victims of cyberbullying can file complaints under the IT Act 2000 also, while institutions are also encouraged to take decisive action against bullies to ensure justice for victims in case of college bullying in cyberspaces. To effectively halt bullying, several measures can be taken by the bullied person as well. That person can document the evidence. In case of cyberbullying, you can save the evidence like the messages and posts to demonstrate the occurrence and the severity of the offense. Complaints against offenders can prompt websites to take action. Oftentimes video recordings and images are not, WhatsApp messages are not admissible evidences in court, but however websites often take reporting in the form of evidence, and you can report their action if they violate the community guidelines, and you can save the evidence, however, to convince your lawyer or the person defending you about what has happened to you, and then you can find how you can address it, right? So the evidence is crucial. Even though it is not accepted in court, it can serve other purposes like prove the severity of the case. The second is utilizing technology. You can use the social media platform safely by reporting or blocking features that can cause harassment, potentially deterring the bully from continuing their actions. If somebody is sending offensive messages, you can warn them, then you can block them, or you can keep your account in private settings so that anonymous strangers or bullies do not get access to your account easily and you do not become an easy target of bullying. You can also secure your accounts by keeping passwords confidential and not sharing information on random calls or with strangers to prevent hacking and other forms of problems. Other issues, you can seek support, you can swiftly seek help by informing the regulatory authorities or consulting a cybercrime lawyer who can guide you through the process and assist in resolving the situation. And most importantly, you can avoid opening emails or downloading attachments that may contain harmful things, because uh, you can avoid downloading those from unknown sources to mitigate potential cyber threats and exercise caution online. That is the best step you can take, that you can be cautious online and not download anything from unknown sources or unknown people. Thus, it's crucial to understand the different forms of cyberbullying and learn the preventive measures. When faced with a bully, one must not fear confrontation and must not be fearful in the first place, and handle the situation very tactfully, showing that knowledge of the law holds significant power. Despite the absence of concrete, dedicated cyberbullying laws, an informed individual's intellect is enough to combat this issue in India. Awareness and understanding of legal principles can overpower the bully's actions, as the strength of the law prevails even in the absence of specific legislation. It is your courage that can be used against you in cases of bullying. It is your fearfulness that can be used against you in cases of bullying, and it is your courage that can serve as the greatest shield in such instances. Have courage, don't be afraid, know your legal rights as explained in the video, and try to handle the situation as tactfully as you can. There are support authorities, agencies, and people available to assist you in these situations, just try to reach out to them in the first place. The authorities are established in the first place for reporting of such incidents. Don't be fearful of reporting if you have an authority visible in front of you, and if you do not have an authority visible in front of you, you can go through your legal rights and the legal resorts. To conclude, I would just reiterate that it is the fearfulness of the bullied person that is the cornerstone of strength of the bully. So, without a comprehensive anti-bullying legislation, the scattered provisions here and there should be on your mind if you face any instance of bullying, and do not be afraid if you are at the receiving end of bullying. And ultimately it is your intellect that can save you in such situations, and hopefully we can hope that India will come up with some anti-bullying laws in the future, considering the precariousness of the situation in in such cases, and how harmful bullying is. So with this, signing, or this is Vidisha Banerjee signing off for today. Thank you.